All right, guys, what's going on? Levi Trumbull reporting here. So, as some of you might now know, the estate of Ashli Babbitt is now suing the United States of America as it relates to her death on January 6, 2021. You guys know the incident very well, I'm sure. That is when Capitol Police shot and killed her as she jumped up, tried to go through that one window in question. Many of you have probably even seen the video where, in fact, that one single shot is rang out by that U.S. Capitol Police officer and shoots Ashli Babbitt dead. Well, now, 3 years later, there is a lawsuit on the books. I imagine that, with the timing was symbolism with the 3 year anniversary of January 6, 2021. But here is a lawsuit. Some people had stated previously that they thought that her estate and her husband would have a claim against the government, and they are going to try to make that claim. So here, right here, actually, you can see on screen we have a copy of the complaint. This is the filed complaint in federal court, and we're going to read you guys some of the text in this complaint. Some of it is interesting. It lays out the story. Nothing quite lays out the story like a lawsuit complaint. They are very detailed. They get to the heart of the matter, and the facts are usually very well founded in the complaint. So we're going to walk you through a little bit of this complaint. So I want to highlight, as you can see, it's a complaint for assault and battery, number one, negligence, negligent supervision, discipline and retention, negligent training, survival, and finally, wrongful death. So these are all individual claims, separate, but all claims. So the first thing it does is, like a complaint, it talks about the jurisdiction statement. The court has subject matter jurisdiction over this case by operation of 28 U.S. Code. And then it gets into the parties. The parties is who is actually bringing the case. Of course, the plaintiff would be the estate of Ashli Babbitt, and then also her husband, plaintiff Aaron Babbitt, who was the husband, again, of Ashli Babbitt, and the duly appointed personnel representative and administrator of her estate. Aaron is a citizen of the United States and a resident of San Diego, California. Aaron brings this action in his individual capacity and on behalf of the estate of Ashli Babbitt. And then, of course, defendant, the United States of America. So this is a little bit of the jurisdictional statement and talks about who the parties are in the case. But I want to get into the meat and potatoes, and that is going to be the facts of the case. Facts common to all counts. Again, those counts that we just listed above, these are going to be the facts that relate to all of them. So this is going to be good, and I'm going to read some portion of this because it's detailed, and it just, this is the meat and potatoes of what happened to Ashli Babbitt on January 6th. So I want to sort of just take you guys through this a little bit. So it says, on January 6, 2021 at 2:44 p.m., Air Force veteran Ashli Babbitt, age 35, was shot and killed inside the U.S. Capitol by then Lieutenant Michael Byrd of the U.S. Capitol Police. The bullet pierced Ashli in her left anterior shoulder, perforated her left brachial plexus, her trachea, upper lobe of the right lung, and second interior rib, and landed in her right anterior shoulder. Ashli fell backwards and landed flat on her back on the marble floor. Video recordings show her alive and conscious, writhing uncontrollably immediately after the shooting. It goes on, Ashli remained conscious for minutes or longer after being shot by Lieutenant Byrd. Ashli experienced extreme pain, suffering, mental anguish, and intense fear before slipping into pre-terminal unconsciousness. The autopsy report identified the cause of death as a gunshot wound to left anterior shoulder with an onset interval of minutes. The fact that Ashli was shot alive, the fact that Ashli was alive and conscious in extreme pain and suffering is documented in videos of the shooting. Furthermore, nothing about the wound track described in the autopsy report would be expected to result in immediate death or instantaneous loss of consciousness, and Ashli's lungs contained blood, further confirming that she was alive and breathing after being shot. Ashli was pronounced dead at Washington Hospital Center at 3:15 p.m. The medical examiner determined that the manner of death was homicide. And then it goes on a little bit more to talk about the fact that Ashli had been living in San Diego, California, where her and her husband owned and operated a successful pool business. It goes on to talk a little bit about that. And it also goes on to talk about how she had planned to attend this rally, and she planned to do it to see President Trump and other prominent conservative speakers. It goes on to say that Ashli loved her country and wanted to show her support for President Trump's America First policies and to see and hear the president speak live while he remained in office. Ashli did not go to Washington as a part of a group for any unlawful or nefarious purposes. She was there to exercise what she believed were her God-given American liberties and freedoms. So, yeah, it just goes straight into it, and it's going into the complaint a little bit further. It shows a photograph of this is the speaker's lobby entryway, which on January 6th, you can see it's sort of busted up. The guy was hitting it with a helmet, and it sort of just goes into the long description of what had happened that day. We're not going to get into all of it, but it goes on, like we mentioned earlier, count 1, assault and battery, intentional shooting and killing of Ashli Babbitt. It goes on, the Federal Tort Claims Act applies to any claim arising out of assault, battery, and other listed torts with regard to acts or omissions of investigative or law enforcement officers of the United States. And then it goes on, and this was because, remember, this officer actually did a lot of news interviews following the shooting. I believe it might have been, off the top of my head, I believe it might have been ABC or CBS he gave an interview to. And it talks about that. It says, Lieutenant Byrd, by his own admissions, intentionally shot Ashli with his firearm. At the time of the shooting, Lieutenant Byrd was an employee of the federal government acting within the scope of his employment with USCP 28 USC 2671. Lieutenant Byrd fatally injured Ashli as a direct result of the shooting. The shooting was not privileged, was without legal justification and non-consensual. Of course, nobody, it's funny they have to lay out the elements of the law specifically when they present the counts. Count 2, like we talked about earlier, negligence. Under District of Columbia law, it is well established that a police officer's lack of due care can give rise to negligence liability for the intentional shooting death of a subject. In a negligence action under D.C. law, a plaintiff must prove the applicable standard of care, a deviation from that standard by the defendant, and a causal relationship between that deviation and the plaintiff's injury. It goes on. Negligent use of a firearm, and it goes on to quote the federal law. It says sworn employees will not discharge any firearm nor use or handle any weapon in a careless or imprudent manner. Sworn employees will carry, store, secure, and or use all firearms and weapons in accordance with applicable laws and the established procedures of the department. This is another law. Firearms may be withdrawn from their holsters only when officers are preparing for its expected, prudent, and lawful discharge to protect themselves or others from, and this is crucial, imminent death or serious physical injuries. To avoid unintentional discharges, officers must keep their fingers off the triggers and outside the trigger guards until firing is imminent. So, yeah, it's giving law to back up their claim. Another claim right here, negligent perception / assessment of imminent threat. Under USCP directive, deadly force is authorized only when the officer perceives that the subject poses an imminent danger of death or serious physical injury to the officer or to another person. So what they're going to be doing is they're going to be making, the plaintiffs in this case are going to be making that repeated argument that there was no imminent fear of death to anyone, therefore the shooting was not lawful. But moving on, negligent use of force, levels and failure to de-escalate. It says this is more federal law here. Sworn employees will use only such force in any situation that is reasonably necessary under the circumstances in accordance with applicable laws and the established procedures and training of the department. Every arrest, search, and seizure will be in accordance with applicable laws and the established procedures of the department. Moving on, negligent perception / assessment of facts. It says generally accepted police standards regulating the safe use of firearms in training and the duty to act as a reasonably prudent officer. Lieutenant Byrd's tactical conduct and decisions preceding the use of deadly force are relevant considerations. In particular, Lieutenant Byrd was required to accurately perceive and assess the facts and circumstances of his confrontation with Ashli before using deadly force against her. So what they're saying is that it was his job to be able to perceive what is a right way, a lawful way to exercise shooting somebody versus what is not a lawful situation where you can do that. And they're saying this is a situation where it was not lawful and he should have been able to perceive that shooting her would have not been the right thing to do, is what they're trying to say right there. And it goes on a little bit more. Again, this is a 32-page complaint. You guys can check it out. If you need a copy, send me an email. I'll be more than happy to forward it to you. It also goes into negligent firing into a crowd. Under basic firearm safety rules, no target is so important that an officer cannot take the time before he pulls the trigger to be certain of his target and where his shot will stop if it misses the intended target, or I can't even pronounce that word, in another direction, or ricochets in another direction. Yeah, another claim they have here, negligent obtaining of timely medical aid. Now, if you guys have ever seen the video after they shoot her, she does fall over, she dies, and it seems like in the video the police officers try to perform some life-saving measurements on her, but not, I guess they didn't do it in a timely fashion, is what this complaint alleges. It says that officers and supervisors are required to obtain appropriate medical aid as soon as possible or practical for individuals who show signs of any injury as a result of use of force, and when the officer or supervisor believes an individual is in need of medical evaluation as a result of any use of force. So they're saying that that the measurements to try to save her were not done in a timely fashion. And it goes on, negligence, yes, this is definitely a negligence case, and it gives some of the reasons why they think that the negligence tort would fit. And then negligent supervision, discipline, and retention of Lieutenant Byrd, that is another count, and it goes on and on and on. Negligent training, they said that the Capitol Police Board, and ultimately Congress owed Ashli a duty to train USCP officers, including Lieutenant Byrd, on the use of force in a manner consistent with generally accepted practices in law enforcement and the duty to act as a reasonably prudent police officer. So I think that might be the, oh no, I'm sorry. I believe this is the last claim in the complaint, and that is a survival action. Under the District of Columbia Survival Act, on the death of a person in whose favor a right of action has accrued for any cause prior to her death, the right of action survives in favor of the legal representative of the deceased. Oh, and there's one more. Yeah, wrongful death. The final one. I think this has to be the final one. We're on page 31. Is the final claim for wrongful death. So again, it just goes into everything. They say plaintiffs reallege all preceding paragraphs as fully set forth herein. So everything before this, they say, can fit under the wrongful death claim as well. And then, as you may have seen, the headline, the plaintiffs in this case, they are asking for $30 million against the United States of America. $30 million. And then this is submitted by Robert Patrick Stite and Paul Orfandes. These are the two attorneys who, I guess they are for Judicial Watch Incorporated. And again, this complaint was filed January 4th, 2024. So obviously January 6th falls on a weekend. So just before the weekend, they filed this complaint in federal court. And we'll see what happens next. Obviously, we're very early on in the case, but I thought I would bring the complaint to you because it's a very well laid out, very solid complaint, and we'll see what happens. There are some people, like I said, who really think that they have a good shot at being very successful at this case. You know, there are a lot of people who are very unhappy with the fact that this 35-year-old woman was shot and killed in the fashion in which she was. So it's on the books. What happens next? My guess, and I don't, maybe I shouldn't throw my opinion in there, but I'm going to. I think there's a very good chance of a settlement. How much? I don't particularly know, but I think the case will probably settle. I think so. So with that, Levi Trumbull reporting. This is the case. We appreciate you taking your time to watch this video, and we will catch you soon. Take it easy.